The next case is Paquin versus the City of St. Ignace. Also a MOA. You have 15 minutes.
Good morning. If it pleases the court, Joseph Kwiatkowski on behalf of Fred Paquin. On a happy note, I bring you greetings from Sheboygan County, where I practiced law and served as prosecutor and judge, and to tell you that the new circuit judge, Aaron Gauthier, is doing a marvelous job. He has caused problems for me because he's my nephew, and I have to disqualify, or he has to disqualify, unless the prosecutor waives it, which thankfully they have waived. So I told him he was going to hurt my criminal practice if he keeps it up. This is a case of first impression. And it's this whole issue is the one that you directed us to brief in a supplemental briefing after we both submitted our appellate brief and the response. And the issue is whether the plaintiff holding an elective office and being employed by an Indian tribe constitutes any elective office or position of employment in local, state, or federal government under Article 11, Section 8 of the Michigan Constitution. There's no definition of local government in the Michigan Constitution, but I've looked at many statutes in Michigan, citing MCL 3.252, 15.501, 18.1701, and others, and the definition of those statutes indicate local government is a village, a city, a township, or a county. Nowhere have I found a definition of local government in any statute in Michigan or other provision that includes a sovereign Indian tribe. When we're looking at constitutional construction, I think one of the principles is what is the common understanding? And I would submit to you, if you ask even lawyers or non-lawyers what they consider to be local government, they wouldn't include the term, oh, the sovereign Indian tribe or the casino down the street. They would say, oh, that's our village, our city, our township, or our county. They wouldn't include sovereign tribes. What the Attorney General has done and the Court of Appeals, in my understanding of how you analyze and interpret the language, is impermissibly expanding it to say that a sovereign Indian tribe is local government. I think the implication of saying that a sovereign Indian tribe is local government has far-reaching implications for all the tribes in Michigan. And even the Attorney General, in their responsive brief, cited that you may be concerned with how this would open the door to similar constitutional interpretation. And they then stated, however, that's unlikely. Well, it doesn't matter if it's unlikely. If it happens, it's going to have far-reaching implications for our state. The drafters of this language, Article 11, Section 8, specifically used the phrase local, state, or federal government. Had they wanted to include sovereign tribes, they certainly could have. It's not a secret that we have so many in the state of Michigan, it's all over. They could have easily put that language in the Constitution. but they didn't. When we had a hearing in this matter in front of Judge Carmody on July 22nd, 2016, we were arguing about this, and the Attorney General at that time, and it's in page 29 of the transcript of that, which is in the appendix, stated, quote, "We're not arguing that the tribe is a local unit of government within Michigan. That's not what we're saying at all. I totally recognize they are not a unit of the state of Michigan. But now they have changed that position to say they are a local government." And when you look at this issue, and you look at the local government versus state government and federal government, local government being a village, a township, a city, or a county, those are political subdivisions of the state of Michigan. They're separate and distinct from an Indian tribe. For example, a tribe is sovereign. It's created through a treaty between the United States and the tribe. Only the Congress of the United States oversees the tribe. The membership for belonging to a tribe is based on your ancestral history, not your residency. And they have a fairly wide geographic expanse. If they claim certain lands are sovereign, they can, like they have in certain parts of northern Michigan with the Sioux tribe of Chippewa Indians, they've got casinos and other facilities all over northern Michigan, both upper and lower. Townships, cities, villages, and counties don't have that. They are specifically geographically defined because they're a political subdivision. And you can be a resident of a township, city, village, or county based on where you live within the boundaries of that subdivision, but you can't belong to an Indian tribe unless you have the correct ancestral history. Indian tribes have gaming. None of these other political subdivisions have that. And most importantly, the distinction is the tribes have courts and separate entities for resolving their disputes where there's no courts in the township, in the city, the village, or even the county. So they're separate and distinct entities. And
Counsel, I know we're here thinking about whether Indian tribes fit into this statute, but help me understand how broad the scope of the phrase, the entire phrase, local, state, or federal government is. Do you have a theory, for example, as to whether that would include any state in the United States, or whether it has global reach, or how should we think about the phrase taken as a whole? I'm just trying to understand where I should be. Is it just things that happen in Michigan? Or, you know, if you're the mayor of Lansing, or is it if you're the mayor of Windsor, should that matter to us?
Well, that's
or what if you're the mayor of, what's the capital of Cuba? You know,
Havana.
Havana. You're imprisoned by the Castro regime. Is that what should we think that's what the legislature was getting at?
I think that's the exact concern that I have in the abuse of expanding it and not strictly construing it, Justice Viviano. And
I think the proper response is we're trying to give it a reasonable construction, but I'm just trying to think about what the phrase means. You know, usually we break these phrases down into their constituent parts, but I think in this case the phrase might derive meaning taken as a whole. And I'm trying to figure out what that meaning might be so that then I can answer the next question, which is, do Indian tribes qualify?
well, the Attorney General and the appellees have argued that it includes the mayor of the city of Windsor, different country, as well as Toledo, Ohio, different state. And that, in my brief, I postured, well, does that mean the country of Iran? How about North Korea? And the plight of our poor United States citizen, Otto Warmbeck. I mean, if you start doing that, then where do you stop? I think it has to be a reasonable construction based on a common understanding of the word local government. And local government has always been understood to mean a city, a village, a township, or a county, because those are political subdivisions within the state of Michigan. And I'm reminded of a quote, bless you, from 2004 by Justice Markman in the Tomac case. And in that case, you were addressing the issue of intergovernmental agreements, if you recall, and whether the governor had the power to do that or it had to be by bill. And you first said, quote, "First is specifically limited to agreements with other states, the United States, the Dominion of Canada, or any political subdivision thereof." And you then said, "The power to enter into an intergovernmental agreement within Indian tribe is conspicuously absent." And so what we find in Article 11, Section 8, is what is conspicuously absent is the phrase Indian tribe. And that's why we submit that Mr. Paquin should not be subject to the restrictions that are contained in Article 11, Section 8. And I think it's easy to slip into this idea that the ends justify the means. Okay, well, gee, we can't have him serve on the city council in St. Ignace. Can't trust the voters if they find out he had a conviction of this sort, because he had a conviction while serving as an employee in the Indian tribe of the Sioux Chippewa Indians. Well, you can't let the ends justify the means any more than you could say if a person was given a confession that was taken improperly by the police, that you could allow it in because he committed a crime and the ends justify the means. So it's our position in this case that the word local government, as you've asked us to phrase it, does not include a sovereign Michigan Indian tribe.
Mr. Kwiatkowski?
Yes.
In your complaint, Mr. Paquin sought a declaratory judgment to the effect that he's eligible to hold a position on the St. Ignace City Council if he won the November 2015 election. I'll take constructive notice that that November 2015 election has passed. In light of that, why is this case not moot?
Well, it's not moot, Justice Markman, because he first tried to get on the ballot, and then the time for that to happen, because they refused to put him on the ballot, lapsed. And so then he tried to get on again, and then this case has taken such a length of time that he wasn't able to get on the ballot. But there will be another election.
Has he pled that he may be running in that another election?
He will be running, yes.
But has he pled that?
No, he has not pled that.
Wouldn't that seem to be at least one possible prerequisite for an assertion that this falls within the mootness exception, which I guess is your argument that this is a case capable of repetition, yet likely to evade review?
Not at all. Here's why. Whether he seeks election in the future or not is irrelevant to the question of whether or not you make a finding that a sovereign Indian tribe is local government. That has an implication beyond Mr. Paquin, well beyond him.
I know, but we don't tend to resolve cases that we believe are moot at the time they're argued.
Well, I still believe that he intends to seek the election. He could amend his pleadings. We were asking for a declaratory judgment.
Well, it's a four-year term. It's not a two-year term. I understand the argument that a two-year term may make it unlikely that somebody can proceed through the process in a sufficiently timely manner. A four-year term would be a little bit, make the mootness argument a little dicier, would it not?
I'm not sure it is a four-year term, to be honest with you, Justice.
I thought it was a four-year term, but there are elections every 2 years.
Yeah.
But even more consequential, it seems to me, is that the Constitution in Article 11, Section 8, states that the provision that we're discussing, that's at the center of this case, pertains not only to state or local elective offices, but to positions in public employment generally that are policy making. And at least in the state of Michigan, it's not clear that we focus only upon the circumstances of the party involved as opposed to whether or not the issue is going to perpetually evade review. And given that there's no timing at all for somebody who's seeking a appointive, there may be no timing issue at all for somebody who's merely seeking an appointive position, why should we assume that this is going to be an issue that will perpetually escape review? If, for example, there was some executive appointment that Mr. Paquin was eligible for and he pursued it, why couldn't he proceed through the process in the normal course of things?
I'm not sure I understand your question, to be quite honest with you. Mr. Paquin
The question is, why will this issue perpetually avoid appellate review, given that it doesn't apply exclusively to elective positions that may have time limits of 2 years or 4 years?
Well, Mr. Paquin filed a complaint seeking a seat on the St. Ignace City Council. He is seeking a seat there. I don't think he has to amend his complaint to say that he's planning to run in the next election or thereafter. And I think this issue will pervade itself with the number of Indian tribes that we have and the number of people that are subject to running for seats outside of that tribal employment or outside the political structure of the sovereign Indian tribe. And so it's not going to go away just because Mr. Paquin doesn't run in the future.
It's not that it'll go away, it's that it can be resolved in the normal judicial course. It can be resolved.
How would it
And
be
thus
resolved?
and thus the mootness exception wouldn't be applicable. Because if the mootness exception is not applicable, it seems fairly straightforward that this case is now moot. There's nothing we can do to place him in a better position than he is right now.
Oh, I disagree. I think by ruling that a sovereign Indian tribe is not local government, you can place him and others similarly situated in a position to seek election on those
But we
city
typically
councils.
do that in the course of cases and controversies, not just in terms of imposing our judgment on what a statute means where there's no case and controversy before us.
But it is this court's duty to interpret the Constitution and to make decisions as to whether or not the language of that Constitution would apply.
In the course of a case or controversy.
And this is a case.
In the course of a live case or controversy, one that's not moot.
Thank you, counsel.
With all due respect, I think it is live.
Thank you,
It's not
counsel.
moot. Thank you.
Thank you.
Good morning, Heather Meingas on behalf of the Attorney General. And with me at council table is Deputy Solicitor General Eric Restuccia. This court should deny leave in this case or otherwise affirm the Court of Appeals. That court correctly held that plaintiff's position as chief of police and member of the board for the Sioux tribe were positions in local government for purposes of Article 11, Section 8 of the Michigan Constitution. Contrary to plaintiff's suggestion, the phrase in local, state, or federal government is not limited to subdivisions of this state, subdivisions of another state of the Union, or even a subdivision of the United States. Rather, it broadly encompasses any organized body that functions or has the attributes of a local government, a state government, or a federal government. The text of Section 8 supports that construction, given the absence of a preposition like of or the modifying phrases of this state or in this state that directly precede the relevant language here, and the fact that it applies to any elective office or public employment position in local, state, or federal government, the any indicating a broad swath. This language it's unique to the Constitution, but the people who ratified it intended it to encompass a broad array of misconduct in public service in order to further the purpose of Section 8, which is to help protect the public by attempting to ensure that trustworthy individuals hold elective office and positions of public employment. applying Section 8 to the plaintiff's conviction arising out of his service to the Sioux tribe plainly furthers the purpose of Section 8 no differently than if the plaintiff had been serving as a city council member for the city of St. Ignace or as that city's chief of police. There's no difference. And applying Section 8 to plaintiff does not in any way impinge upon tribal sovereignty. Section 8 is not being applied or enforced against the tribe. The question here is simply whether the Sioux tribe is a government employer for purposes of Section 8. It's an element. We need a government employer here. And the answer to that question is yes. So I think the first important point that we need to understand, and where I disagree, I think, with plaintiff's argument is this is not limited to subdivisions of the state of Michigan. There is no limiting language in that. As you saw from our brief, we sort of divided Section 8 into components. You have sort of an ineligibility component in the front half of that provision, and in the back half, you sort of have the covered felony component, what's encompassed. And from the front half, you see clearly that the ineligibility is limited, of course, naturally, to elective offices and employment in this state and of this state.
Let me ask the specific question, I guess. And I might have misspoke earlier about the legislature. It's, what's the common understanding of this phrase, local, state, or federal government, to the people of Michigan when they ratified this amendment in, I think, 2010? Is that right?
2008, I think. Maybe it was 2010.
All right.
Like that.
So, 10 or so years ago.
Right.
That's the question. So I find it striking that your position is that the people of Michigan, when they saw that phrase and they voted on that phrase, they were thinking about, as counsel suggested, someone who was charged with a crime in North Korea or in Cuba or in some country that has a much different system than ours. In this particular circumstance, that's what the people had in mind. That's your position?
Well, our position is that it would apply to a foreign country or a foreign nation.
Well, only
That's
if it's
not-
part
not
of the
what we
common
have.
understanding of the phrase when the people, the minds of the voters when they voted on it, right?
I think you have to look at, well, I think it's clear that if you'd asked an ordinary citizen and you described the two factual circumstances, well, the plaintiff incurred this conviction while serving the Sioux tribe, and we have Mr. Smith over here who has the same conviction while serving in the capacity as a city council member for St. Ignace, and he'll be barred, and Mr. Paquin is not, when they have essentially the same felony. I think people, the ordinary understanding people would be sort of flabbergasted.
Well, they
at that
might have
question
said,
why.
we should have had better language. We should have thought about this.
Well, the question
should
is
have
whether they
inserted
need
tribes.
better, whether they
We
need
should
better
have
language.
inserted tribes. We should have said other countries, any other country, anywhere in the world, where two or more people get together and do anything, that would be considered sort of a government, right?
Sure, they could have done that, but the question here is whether they need to have done that. Because if we agree that this latter part of this provision clearly applies outside of Michigan, and I don't think there's a dispute that it applies to like Toledo, Ohio, or another state, then it makes perfect sense that the
Can I ask about the word federal?
Sure.
So it says it applies to federal governments. Would it
Right.
apply to a unitary form of government?
Well, I think
I mean, other countries that are not federal.
if we're,
Federally
again,
based.
going down sort of the other country
You're right.
route, we would be sort of working on what's a general sort of definition of the word federal. I mean, I looked it up yesterday on Merriam-Online-Webster, dictionary. It's not like the first thing you see is the United States of America. You see a system of government. It is a central authority over smaller units, political units that have ceded some authority to the central authority. That's what federal means, like federal system.
So
So if we applied it to another, I think we would be working within that rubric. Is there another country that has sort of a similar type of system?
And so countries that don't, we're not concerned about protecting our voters from fraud committed by individuals serving in positions in those countries, but only in federal government?
Well, I do have to work with the language that we have. and
Well, I'm
so,
just saying,
the
if
term-
federal is saying a government like ours, like our federal government, our national government, why then does
Well-
that same understanding not apply to the term state and local?
Because what the legislature did and then the people did here was let's back up a second. If we agree that this applies outside of Michigan, it makes perfect sense here that the legislature chose to use broad categories of government, a local government, a state government, a federal government, because it would be virtually impossible for the legislature to include a list of what every entity or body that might be
It's
local
sort of
government.
interesting, because it doesn't say A, it just says in local, state, or federal government.
Right, I think without a preposition like the or of, the natural reading would be in a local government, a state government, or a federal government. There is no qualifying or limiting language, and I think it's very clear, looking at Section 8, that the absence of that when it's compared to the first half of that provision. And I've also looked at other provisions in the Constitution. I would direct this court to Article 3, Section 5, Article 4, Section 7, 8, and 9, and 10, and Article 7,
Do
Section
you
28.
think it would be unreasonable for me to conclude that federal government means the United States government?
Yes, I do. Because what is the...
Do you think the position that Justice Kavanaugh so astutely pointed out, the minds of the voters was they only were worried about convictions in other countries who had a federal system of government? That's when I checked the box in the ballot box, that's what I was thinking about?
I think that would be sort of the natural limitation to the end of this language and what the term federal is, and simply giving it sort of an ordinary dictionary definition of what federal means.
Let me ask you this, if I conclude that federal means the United States government, and state government means a government of one of the states in the United States, do you win or lose the case? Do you have an argument or a theory as to how you would still, your client would still prevail?
If you read it the same way plaintiff does, which is a local government.
Well, I'm reading the other terms because I'm trying to figure out if they
No, I
have
know,
a
but let
bearing on the local government theory that you're advancing.
Right, but he's reading it as a local government of a state, of this state, or of another state of the Union of the United States of America. That's not how I read it.
But if I
There
go
isn't a
down the road that
subdivision.
far with him, are you lost? Is it over?
No, because if you take the word federal, what does federal mean for our system of government? Our United States is made up of the national government, which is clearly captured, the 50 states, the numerous territories, Washington, D.C., and the Indian tribes. That's our federal system. So to me, the word federal, if we want to keep it cabined in our
How
system.
did you get the Indian tribes in there, exactly?
Yes, Indian tribes are there
They're
too,
separate
right?
sovereigns, right? All the other ones sort of come underneath the umbrella we're under. They're
Not
separate
territories,
sovereigns.
not really territories. They have their own civil governments. They have
Congress has no
representation.
control over the territory?
The Congress has plenary authority over the territories, just like they do over the Indian tribes to some extent. So they are a similar,
Wait, that to some extent qualifier, might that matter?
well, no, I don't
They
think
have
so.
some authority,
Because
but
your
the Indian
argument is
tribes are separate sovereigns. I don't think Guam is a separate sovereign, is it?
they are subject to the plenary authority of Congress. Similar to, Indian tribes are subject to the plenary authority of Congress, right? In that sense, I'd be happy to say a territory is a state. To me, the legislature clearly intended to capture a broad array of criminal conduct. That's why they use this very generic phrasing, sort of category phrasing, instead of inserting the words the or making it explicit. If we took Mr. Paquin's argument that this is somehow limited to cities, townships, villages, and counties, we would roll out many local government units here in Michigan.
What will we roll out? What would be rolled out under his argument, under his theory? Explain to me specifically what was it that we would be ruling out? What would be excluded?
Well, school districts. I think most people believe that, and for many statutes in our Constitution, a school district is a local unit of government.
What else?
Article 7 in the Constitution about local government also includes metropolitan authorities. It includes authorities created by interlocal agreements. We're potentially, by limiting it to this very traditional sense of a subdivision or a unit of the state, we're ruling out potentially application to what otherwise I think would be pretty ordinary understanding that a school district or
School
something.
district might be considered a subdivision of the state government, wouldn't you think? Regulated by state law, created by
Right,
state
but
law?
I'm pointing out that his argument is that it's a city, township, village, or county. That can't be, because that doesn't even work for Michigan. That potentially rules out all different kinds of what we might argue to be a local government. Does a local government have to be a city, township, or village? I don't think so. I mean, Article 7 is replete with references to other types of authorities. You have metropolitan authorities, you have entities created by interlocal agreements. Are we going to rule those out categorically right now that they're not a local government?
But I
Isn't there a
think that-
uniqueness to the, isn't there a uniqueness to the tribe?
Yes, I agree that there is a uniqueness to the tribe, and I think I want to make sure that we understand that this case isn't about somehow changing or modifying or the legal status of tribes. What we're saying is, at the bottom here is an Indian tribe a government? I think an Indian tribe is the government. If you look at a generic term of government, which the Court of Appeals used,
But of course, it's a government, that's not the question. The question is it a local government? Indian
Well-
governments write constitutions. Do local governments write constitutions?
well, the question is it a government? I would submit it's a government.
Yeah.
Right, it's a political organization, it has a governing body, it's a government. So then the question is, if it's a government, does it fit within one of these enumerated levels of government or categories? Is it a local government? Is it a state government? Is it a federal government? I think I can make arguments that it fits in any of those boxes.
The one you came to this court with is that it's a local government, although apparently that wasn't the one you made in the trial court. What was the one you made in the trial court?
No, it's the same argument. We've been consistent throughout. I'm saying here, yes, we landed on the local government aspect not because we think they're a unit of Michigan, but what sort of is the practical functioning of the Sioux tribe in the Upper Peninsula. They have a membership of 40,000. They provide governmental services in a range, in 7 counties. What are they like? They're like a big city or a big county.
Well, they're like a local government,
like a
but
local
they're
government.
also
They function.
dislike a local government,
Right.
correct? Because they are a sovereign nation.
Right, and that's why I also think in
So
hindsight.
why acting like a local government make it a local government?
The question is, does it fall within any of these levels or sort of broad category of government for purposes of this section? Does it make sense to rule them out? What I hear from all of you is it says it need to say specifically tribal government. It need to say local, state, federal, or tribal government. Well, under that rubric, did it need to say Washington, D.C.? That doesn't fit neatly in any of those boxes, but I think the people would be flabbergasted if the mayor of D.C. got convicted of a felony, moved here, and then was able to run because D.C. doesn't fit neatly in a box. It's a government.
But isn't there remedy then to not vote for him? As opposed to, I mean, there is a remedy, there's a political
Yes.
remedy to not vote for him, but that doesn't mean that's not a justification for keeping him off the ballot if the constitutional language permits it, right?
Right, there's a remedy, but the people chose to enact this constitutional provision after the Kwame Kilpatrick scandal and all of these types of scandals where we've had people in public positions abusing their offices. They voted to put this in the Constitution because we didn't even want these people to get onto the ballot and before the people. That's why we have it. And it was intended to apply broadly. We know it applies outside of Michigan. It's pretty clear it's not limited to in-state. And once you go outside the state of Michigan, then it would be almost impossible to decide for the legislature of the people to have listed everything that might be a local government, everything that might be a state government, everything that might fall within the federal government in one constitutional provision. It's not like they've listed everything, it's easy to run back and amend it, right? It's a constitutional provision. We'd have to go back to the people and say, we made a mistake. We want to broaden this category and add another federal government or entity in there. So what they chose to do was simply use these broad categories that are not limited to sort of subdivisions of, but something that falls within the nature of that has the function or the attribute of a local government. I think you could argue that a tribe, if we're not comfortable with local government, and I get that, then it seems to me you could make a simpler argument that for purposes here, they're more like a state. Do they interact more as a state here, speaking to each other, Michigan and the tribes speaking to each other? And in that sense, are they more like a state government? Would we consider, there's lots of case law, especially with the territories and with Washington, D.C., and tribes themselves about where they might fit in or how they fit in different pieces. Sometimes D.C. is considered to be a local government. Sometimes there's cases saying it's a territory, and sometimes it's a state. So
I do think
not
that-
everything fits in a box.
I do think Justice Viviano's much earlier point about us having to look at these terms not in a discrete fashion, but as a collective, does communicate something about the hierarchy that's being referred to here. And I tend to think it's a more traditional kind of American and Michigan hierarchy than you may be arguing, but That's just one justice's view, but I do want to ask you before time is up, knowing of your office's concern for the maintenance of the integrity of the judicial power on the part of the highest court of our state, what is your view on the mootness issue that I've raised?
I hadn't thought of it until, of course, you asked plaintiff's counsel, and certainly that's an attractive argument to me today.
Is it a correct argument?
I think I agree with your point to the extent this section covers public employment positions, that's kind of a real rolling thing that can happen, that doesn't have sort of a finite window of time in which you might, well, though maybe it would, if you're posting, if you've applied for a position at our department, the posting ends and you don't get it. But moving to sort of like the elective aspect, to be fair, I would say the plaintiff filed his case timely, and we didn't, it didn't resolve itself within an election cycle in time for him to be on the
But
ballot.
that's just saying it's moot.
Well, I
Obviously, it's
think-
moot, we all know it's moot, but
For
the
that
fact that
cycle,
a case is
yes.
moot doesn't mean that it's going to perpetually evade judicial scrutiny in the future, of course.
I think the argument as to whether it avoids mootness because it's capable of repetition yet avoiding review, I think that he probably has a rather compelling argument on that point, because the example is here that we didn't, the suit was filed in 2015 and it's 2019. Obviously, we didn't resolve the case in time for him to make the ballot. And so, as much as I would like to agree with you that, yes, I think it's moot, I'm not, I won't say it's not, but my hesitation is that just factually here, we didn't
But
keep
do
it
we
in the
adopt the
cycle.
federal rule or the state rule? If we adopted the federal rule, it wouldn't be decisive that he couldn't secure a determination in the future. It would be that nobody could secure a determination. Are these kinds of things important?
The doctrine of mootness, or how we apply that, is that important?
How we understand the judicial power of this state, yes. To what cases and controversies does it properly apply?
Yes, of course, it's important and significant. So was this question.
But it's evaded your review thus far.
Yes, that's what I would say.
Thank you.
Thank you, counsel.
Right,
These are
thank
off
you.
your elections?
Sorry?
Right? The election was 2015, so there's no
He filed in
election.
2015, so I think he was hoping for the election that fall, and we
Right.
missed that. We've missed all
Oftentimes,
of them.
cities are off your elections.
They're
now,
off
and there's-
here.
Is there a deadline or a filing deadline the court should be aware of in this case for the 2019 election?
I don't totally know for sure what the filing deadline for a city office would be, but certainly it has to be in time to make a print of November ballot. So I will believe the deadline was somewhere, it's probably in September for
Thank
an
you,
off
counsel.
year. Thank you.
The case will be submitted.